in Michigan versus Brandon Michael Sias. I take that back. That was the one we just did. All right. Our next file is People of the City of Michigan versus Seth Alexander Mitchell. The file number is 22-13461FH. Appearances, please.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Mitchell. He joins me at the table.
Thank you. Also before the court this morning is Mr. Sean Van Atwell from the Michigan Department of Corrections, serving as a probation officer on this file. We were here last, looks like January. Well, yeah, back in January. The defendant was arraigned on a probation violation, requested warrant that included 2 counts. He was not guilty. A plea was entered on his behalf. He requested appointment of counsel that has been facilitated. And so we are back here today for our probation violation hearing. This involves 2 allegations. A allegation of the defendant assaulted, threatened, or abused a person named Madison Lord on or about January 9th of this year. What are we doing today, Mr. Harrison?
My understanding, we intend to conduct a hearing.
All right, thank you. Mr. Carnes?
I call Agent Van Atwell.
You may take a stand. Before you do, of course, I'll swear you in. Swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth, sir?
Yes, Your Honor.
Thank you. You may take a seat. The court takes additional notice that this is Sean Van Atwell from the Michigan Department of Corrections, who is the probation officer. Thank you. The court also will take judicial notice of the terms and conditions of probation that are contained within the court's file. They were signed by me and then subsequently acknowledged by the defendant. One moment. Originally, there was a delay of sentence that was withdrawn. Then the terms and conditions were signed by me on January 29th of 2024. Acknowledged by the defendant on January 2nd of that same year. I'm sorry, February 2nd of that same year. Mr. Carnes, you may begin.
Thank you. Mr. Van Atwell, can you please state your name for the record?
Sean Van Atwell.
And what, if any, recent violation have you seen on Mr. Mitchell?
On 1/12 this year, 26, I was notified that we were arrested in Grand Traverse County for domestic violence and assault less than murder by strangulation.
And what, if any, specific information did you receive regarding that alleged assault?
I received a police report from Grand Traverse Sheriff's Department that I reviewed. Just detailing the investigation.
For the record, I'm approaching the witness with what's been marked as People's Proposed Exhibit 1. Do you recognize that document?
Yes.
What is it?
It's a police report that I received from the Grand Traverse Sheriff's Department that I reviewed.
At this time, I would move to admit People's Proposed Exhibit 1 and publish to the court.
Mr. Harrison, other than the typical objection because of the lack of application of the rules of evidence, do you have any other objections?
I just have a couple of more here.
All right.
The police report in question, does it have an incident number attached to it or something that we can identify?
There's a case number 2026
See that?
0000573.
573 are the last 3 numbers.
Yes.
Okay, and it's from the Grand Traverse Sheriff Department. I believe that's the same report that has been shared with me, so I have no objection, Your Honor.
Proposed exhibit number 1 for identification is hereby admitted. Mr. Carnes, you may continue, sir.
Your Honor, I would ask to publish that exhibit to the court at this time.
May I take a look at it, please, Mr. Vanetta? Thank you. I now have in my hands People's Exhibit number 1. And again, it's the Grand Traverse County Sheriff report for the case number referenced or incident number referenced by Mr. Vanetta. One moment. I'll note that it reports an alleged incident date of January 9th, 2026. Which is consistent with the allegations on the requested warrant. So references on the two Madison Board and Seth Mitchell. One moment. All right, I have read the entirety of that exhibit, which consists of 5 pages. I'm returning it back to the witness. Mr. Carnes?
No further questions, Your Honor. Thank you.
Mr. Harrison, any cross-examination for Mr. Van Atwell?
After reading this report, did you come to a conclusion that Seth had committed some act that was violative of his probation?
I felt there was sufficient information indicating a violation of probation.
And specifically what was the violation?
That there's 2 counts in the warrant. One was essentially assaultive behavior, technical violation. The other one was assault and or battered, I believe was the verbiage I used. It was a non-technical violation.
So you allege that that was new criminal activity, therefore making it a non-technical violation?
Yes.
Did you read this report in its entirety before coming to that conclusion?
Yes.
You'll, pardon me. At one point in the police report, there's discussion of a video that's viewed by the officer on scene.
Yes.
Did you yourself view that video?
No.
Thank you. Nothing further.
Mr. Carnes, anything further?
No, Your Honor. Thank
Mr. Van Atwell, you may return to your seat. Mr. Carnes, anything further to present?
you. No, Your Honor.
Mr. Harrison? Ball is now on the defense side.
Yeah, no witnesses today, Your Honor.
Thank you. Any argument, Mr. Carnes?
Your Honor, the report contains statements from the victim about strangulation and battery, and marks on her body observed by the arresting officer. Those statements that she made, I think there's a preponderance of evidence to find the defendant guilty of the technical violation of assaultive, intimidating behavior, as well as the non-technical violation of new criminal behavior. I'd ask the court to do so. Thank you.
Mr. Harrison?
Well, if you read the report in its entirety, Your Honor, and I know you have, you can see that this is a typical, perhaps not typical. This is a case of a he said, she said. They both have different accounts of the events and how they transpired. And there appears to be some video evidence that at least the officer in question did confirm that, yeah, it did look like she threw a knife at him, et cetera, et cetera. The interesting thing is this case is still pending in Grand Traverse in the district court, I believe. So we don't really have a disposition up there as to what any of this means in the real world. I understand the much, much, much lower standard of proof required here But the only evidence that we have is hearsay, and in some cases, hearsay within hearsay. Again, I understand the rule of evidence still applies. It's still not very reliable evidence that frankly, we're not in a position to do much in the way of refuting due to the fact that the case is still pending up there. Thank you.
Thank you. Mr. Van Atmel, what was the last sentence this court gave to Mr. Mitchell? Was that the one back on August 28th of 2025?
Yes, that was 30 days jail, 30 days credit.
On
He's since been in jail since 1/12/26. So
what's the credit?
the total credit by my count is 86 days as of today.
That's that's not since he's been in jail, but that's with the 30 days from before.
Yes, that's counting the 30 days.
And he served that full 30 days to take that time. Is that right?
Yeah, I believe that he had already had 30 days and he was just set time served.
The burden of proof at a probation violation hearing pursuant to the court rule 6.445 is a proof by preponderance of the evidence, which is again, as Mr. Harrison correctly stated, is much more easy to read compared to proof beyond a reasonable doubt. I think I understand what Mr. Harrison was trying to say when he talked about all the way through the word typical. It's a scene that is unacceptable. The police report described two adults by age with a child, a young child, living in horrible conditions. Food, garbage on the floor, broken mirrors on the floor, and apparently under some kind of influence of substances. We don't know if there was any testing done of the defendant, but here's what I saw. I saw a combative situation between two people. They had both sat in there. They were fighting for the last couple days. And I don't think that the victim in the file, Miss Lord, was the one causing the bruises and injuries to her. But I also don't think it was that the defendant, Mr. Mitchell, is also causing the marks or I think red eyes and things like that I heard about upon himself. This isn't so much about proof of a, well, that is proof of an assault, threatening, intimidating behavior. This is how people choose to live. I guess that's up to them. But it's clear to me that Mr. Mitchell was a part of that. Fighting up and beating on a woman. Good job, Mr. Mitchell. Standout young man. The court finds the defendant guilty of the two violations. Now, let's jump to sentencing. Let's just do that, take care of that right here. Mr. Van Atmel.
Yes, Your Honor. He's serving for 2 counts of police officer resist obstruct. Sentencing guideline range is 0 to 11 months on each. He has originally sentenced to a delay, was unsuccessful on that, and then completed almost 2 years of probation, and is now essentially been unsuccessful on that. He has 3 prior technical violations, total jail credit, 86 days. Needs though $1,476 in fines and costs. I would recommend 300 days jail, credit 86 days served, probation terminated, preserve fines and costs.
Mr. Carnes.
Thank you, Your Honor. I had the same question as the court as far as substance testing, because that's the history here with the defendant. He was dancing in the road and then laying down in the road and then struggling with officers on the underlying offense. And it was all because he was very, very drunk. I don't recall the exact number, but it was up there. And then we have this behavior. I think ultimately, Mr. Van Ackmel's sentence is reasonable. I'd ask the court to follow it. Thank you.
When it said dancing in the street, did you describe the dancing? Was it like the chicken dance, the Macarena? No?
I'm sorry, Your Honor, it does not give that specific.
Mr. Harrison?
Well, look, Your Honor, every time we have a hearing like this and the only evidence is a police report, it gives me great pause. Not because I think policemen routinely misrepresent the visual evidence that they have in front of them, but because the statements made in that report are deemed so unreliable that if the rules of evidence did apply, that would not be an appropriate exhibit in a legal case. I think as the court has recognized, there's a lot of leeway here. If there is a struggle with alcohol or some other substance, he's been on probation for almost 2 years. Yes, he has not had a perfect record. No, he's not proud of the circumstances that brought him in on the first case or this one. But I just think jumping all the way up to 300 days is a bit much under the circumstances. And I would encourage the court to impose a much lower jail sanction up to and including time served. Thank you.
Thank you. Mr. Mitchell, anything you wish to say before the court issues a sentence? All right. Then of course, what's owed on fines and costs?
It was the balance that Mr. Van Ackmel said, 14,
How much has he paid on?
he made a $150 payment 2 years ago,
Wow.
$1,426.
All right. Well, Mr. Van Atwell, do you have the PSI there with you? So prior to this, Mr. Mitchell did not have any significant criminal history. He did have some priors. Looks like the court dealt with an R&O back in 2023. And then, well, actually it's the same file, but then we had to redo the PSI after the delay was violated. But again, he does not have that significant of a criminal history. He had an assault in 2020, destruction of property in 2016, another assault in 2021, and then the assault the assault resist destructive police officer that occurred here in 2022. So out of the defendant's 4 criminal entries, 3 of them are assault conduct, and he finds himself here also dealing with assaultive conduct. Well, I understand that there could have been 2 people in this fight, but one of them was a mother with a child. So the court terminates probation, unsuccessful. The court preserves all fines and costs. Considering he's made almost no payments in the last 2 to 3 years here, the court takes that also into consideration, as well as the prior probation violations. The court sentences the defendant to 210 days in jail with 86 days of credit. Did I miss anything, Mr. Van Atwell?
No, Your Honor.
Yes, Mr. Carnes?
No, Your Honor, thank you.
All right, and I'm taking into consideration that he has other charges pending in another county. If there is a finding, I'm taking into consideration that whatever sentence I gave could eliminate all the potential jail credit that he's getting there. That's why I didn't go up to 300. I went with the 210. All right, Mr. Harrison, any questions about the sentence?
No, Your Honor, thank you.
Mr. Harrison, if you could please retrieve from Madam Deputy, I'm sorry, Madam Clerk. Mr. Mitchell.
Thank you.
You're getting 2 copies of 1 document. You'll place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of that document. This document tells you that you have the right to appeal the conviction and sentence in your case. And that's typically done by filing a claim of right to appeal. However, based upon the original plea of this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you and return to the court within 42 minutes. We're adjourned.
Thank you, Your Honor. May I approach?
You may, sir. Thank you. We can next get Mr. Todd Burns, please.